issue worth fighting for. And I'm going to suggest to you that improving your voir dire conditions is such an issue. You really want to fight the judge on this one. Another one is you've got to be willing to accept the responsibility that's in your hands. And the responsibility, in my view, is to hear those two magic, wonderful, glorious words. What are they? Now, shit, man. That doesn't convince me. That doesn't convince me that you believe in those words, that you feel those words. Now let's try it again. What are those two magical, wonderful words? Okay, now we're getting better. Now listen. Action follows thought. If in your heart and in your soul you believe that Billy Joe Bob is not guilty, that you believe that the prosecution cannot prove their case, if you feel it, you will exude it. You will fill the courtroom with the notion of not guilty. When we walk into courtrooms now, because we really do believe that action follows thought and space has memory. Kind of an interesting concept there. The problem is that most of the courtrooms we walk into, the room is filled with the memory of guilty. I don't like that memory. It's like filled with the memory that the prosecution sits here and the defense sits here. Do any of y'all have a statute that says the prosecution gets to sit next to the jury? Does anybody? You do? You need to change that statute. It's a shitty statute. Why do we let the prosecution sit there? Because it's custom. Screw custom. Say to the judge, Your Honor, for the last 1,000 trials, they got to sit there. I want to sit there once. And then for the next 1,000 trials, they can sit there. We will walk into a courtroom. I swear to God this is true. We will walk into the courtroom. We will look to all four walls and say, not guilty, not guilty, not guilty, not guilty. If I have a lot of time, I'll sit in every chair and I'll say not guilty. And then I'll go into the jury deliberation room and fill that room with not guilty. I may write it once or twice too. We got to believe we are coming up to the next millennium. We cannot do the same stuff the same way anymore, folks. The special interest groups hate us. The media hates our clients. The judges hate us and our clients. Prosecutors hate us and our clients. It is time to change that. Because our battle is not with the judge. Our battle is not with the prosecution. The battle is not with that snitch witness. It's a relationship that we want to have with the jury. It's not about battles, if you ask me. And what I mean by that is, I encourage lawyers that when you're examining a witness, look at the jury. Don't look at the witness. Who gives a shit what he says? Who cares what he thinks? All right? When the prosecution's standing up giving his opening, don't look at the prosecutor, look at the jury. Keep your eyes focused on the jury. They are your friends. And in jury selection, that's where we pick our friends. You've heard a lot of talk today about listening. I'll tell you why you want to listen. It improves your relationships. Your relationships with your significant others, your children, your clients, your coworkers, your parents, your siblings, your judges. All improve when you become a good listener. And when you learn to listen to the jury, they will reward you in the jury room. I promise you, I've seen it time and time again. Now, those of you that are in federal court, I know a lot of you are. I'm going to give you a transparency in just a minute. I just came back. Any of y'all ever heard of David Chesnoff out of Las Vegas? What a great lawyer. I just helped David with a jury selection in Mississippi. And we had 4 days of jury selection in federal court, okay? Because the judge wanted to get the jury done in 1 day. But David, because he was persistent, because he was willing to fight the fight, because he was willing to be held in contempt, he appreciated how important the jury selection was. And after 4 days of jury selection, we finally put a panel in there, much to the chagrin of the judge and the prosecutor. But David was doing the questioning. And what I mean by that is, you know, in federal court, the judge will have you submit the questions, right? And then the judge will say to you, now, when I'm finished, what's the judge say? Well, in federal court, the judge will say, if you have any other questions, you know, just bring them up to me and I'll ask them. And, of course, what the judge will do is bastardize the good question and ask it in a closed-ended way so nobody raises their hand. What David did is he just stood up and he said, Your Honor, here's the question I'd like you to talk to the juror about. And then David would turn to the juror and ask the question. He'd say, Your Honor, here's the question I'd like you to ask. And then he'd ask the juror the question. Now, there's no rule that prohibits that. But David said, this is an important case. David said, my client's not guilty. David said, I have to win. And we can win. You know, the problem is we get beat up. That's why so many of us come to the college every year, because we all need to get our batteries recharged, faculty included. This is the place where we have the courage to spread our wings. Tomorrow is the day where you say, I'm going to try some new stuff, because nobody's going to jail today, especially me, right? And I can't tell you the number of times, and talk to any of the faculty, the number of times that we hear back from participants that they didn't think they could do this stuff. They went home, they started doing it in the courtroom, and like all of a sudden, judges and lawyers would start coming in to watch the voir dire, to watch the openings, to watch the crosses, because something new and different was happening. And the different thing was the lawyers were taking control. The lawyers, the defense lawyers, were winning cases. So we are empowering you to have the courage to try these things. There are two things you cannot say tomorrow. You cannot say, I can't do that in my jurisdiction, and you cannot say, my judge won't allow me to do that. You cannot say those two things, okay? In Harris County, in the federal court in Houston, for years, it was just like every federal court. Lawyers didn't get to do any voir dire. But for years, lawyers started fighting it. And now, in every court, well, almost in every court in Houston, in the federal court, judges give some voir dire. It's ranged from 10 minutes to an hour. But that's because the lawyers fight. We file the motions to suppress, even though we know the judge is going to probably deny it, but we put up the fight. We've got to start putting up that fight for the voir dire. Robert, what are you talking about? Fight for a motion for a jury questionnaire. How many of you have ever gotten a jury questionnaire? Okay, see? Now, next year, I want every hand to go up. We've got to be fighting for jury questionnaires. People will put on paper what they will never say in a courtroom. And here's your argument to the judge. Judicial economy. Right? That's almost as good as plea bargain. Right? Man, they love hearing those words if it will save the court time. All right? So you want to fight for these jury questionnaires, and on the Friday workshop, we'll talk in great length about how to get a jury questionnaire, what to put in it, how to do the administrative aspects of it, literally go through the mechanics of a jury questionnaire. But I want every one of you, when you go home in 2 weeks, the first case you're in the courtroom, I want you to file a motion for a jury questionnaire. If you're in a jurisdiction that allows minimal or no attorney voir dire, I want you to file a motion for attorney participation in voir dire. And I'm going to give you a case for it in just a minute. All right? So, with those kind of thoughts in mind, let me start with my first overhead. This is absolutely my most important transparency. I want to go over it with you. A message we listen to each moment is that we are all the same. That we all want love in our lives. That gentle is easier than tough. That ego is an inhibitor to flow. That quiet is better than loud. And letting being be all that is. I read this, and I read it, and I read it, and I read it, and I read it. And I turned to Kat Bennett, and I said, Kat, I think I understand it. And she said to me, Robert, if you think you understand it, you haven't gotten the message. And she was right. I hadn't. Jurors don't make decisions up here. Prosecutors and judges like to think so, but we know better. Jurors make decisions with their heart. What their heart says is the right thing to do. We've got to learn to be more like our jurors and less like our prosecutors and our judges. We got to learn to let be all that is. Trust your instincts. Trust your sense. Trust and believe in your jurors, because they will help you if you give them that opportunity. Let's talk about jury selection. There's a case citation. Don't worry about the citation. It's meaningless. Look at the message. If one thing is clear from our published opinions in this area of the law, it's that potential jurors frequently misunderstand the questioning put to them by the attorneys during voir dire. The problem is often exacerbated by the questions themselves. That's a real long way to say we ask shitty questions. It is time to start asking good questions, simple questions, important questions. I don't think any question should have more than 10 words in it. I don't think any question should have more than 3 syllables in it. Why do we use these big words? Why do we use words like exacerbated? Isn't that what guys did when they were 12? Doesn't credibility mean your credit worthiness? What is an indictment? What's a substance? Why do we use these words? I'll tell you why. We all went to law school. We all had a lawbotomy. You know? It's like we think different now, we act different now, we dress different now, we use big fancy words. So when our clients will pay us to justify, our services so we can pay off our student loans, I mean, Jesus, let go of all of that. How many of y'all are in a relationship with someone? Okay, now, you ready? How many of y'all, when you've been in a relationship, have had a fight or disagreement with that person? What do they say to you when you're fighting? Stop being alone. What else do they say? Stop cross-examining me! These are the people we love! The hell is wrong with us? Let go of all of that. Be a good listener. How many of y'all during voir dire and you're talking about a juror, you refer to it as the witness? We don't cross-examine witnesses anymore. We don't cross-examine jurors anymore. We become listeners. We become like therapists. We tell them, it's okay. Just tell us how you feel. Now look, you notice how I'm doing this when I'm trying to talk to you? You notice I'm not behind the podium, right? You notice how I try to come right out here and I have my arms like this? I don't want there to be any barriers between you and me. I want to be able to look you all in the eyes and be open to you. I want you to be open to me. You ever see those TV preachers? The kind that want money? Are they like this when they're asking for money? Hell no, they're like this. They've got their hands all the way into your pocket, right? And that's what I'm saying. You want to be this open with the jury. Get away from the podium. I don't have my jacket buttoned. By the way, I wouldn't wear this in voir dire. This is like the power clothing, unless I got to open the same day. I save the power clothing for the power days. Opening, key crosses, closing. I like to wear more comfortable clothes when I'm doing a voir dire because I don't want there to be barriers between me and the jury. Break down the barriers. Let go of the words. Let go of the podium. All right? And just get real with the jury. So, that brings us to the problems with voir dire. Let's talk about the problems we encounter. Well, number 1, time limitations. Any of y'all getting time limitations? Right. It's coming, it's bad, it's horrible. I'm going to tell you one quick war story about a time limitation. The reason we have time limitations is because we are using voir dire the wrong way. We're giving speeches, we're lecturing, we're being condescending. The judge has to protect the voters. Those 40 or 50 or 100 jurors, he doesn't or she doesn't see them as jurors. It's voters. If you're in an elected state, the judge wants to protect those people, right? So you've got to ask good questions. Here's the war story. I'm in Harris County trying a drug case, right? Judge calls me up the bench. Mr. Hirschhorn, where are you from? Galveston at the time. I don't know how you do it in Galveston, but in Harris County you get 45 minutes. I said, Your Honor, I think I can do my voir dire in 4 hours. He said, Mr. Hirschhorn, you didn't hear me. I said in Harris County, Houston, Voir dire is limited to 45 minutes. I said, Your Honor, I heard that. And I really believe I can do it in 4 hours. You know what he said to me? Sit down, Hirschhorn. Prosecutor gets up there, does the boring voir dire, 38 minutes, and 15 seconds in, dutifully sits down. I get up there. Everything I'm telling you about, I do. Open-ended, listening, asking simple questions. I swear to God this is true. 3 hours and 40 minutes into my voir dire, the judge says, Mr. Hirschhorn, I'm not trying to rush you. Are you almost done? Oh, yes, absolutely, Your Honor. 5 minutes later, bang, I sat down. The reason is because the judge saw something he hadn't seen before. He saw a lawyer that was listening, asking questions that were simple, that the people could grab onto and intelligently respond to. So that's, you want to keep the judge interested in what you're doing. And I promise you, if you ask these kinds of good, simple, open-ended questions, you'll get more time. Next. Jurors don't talk. Anybody have that problem? Oh, shit, every hand in this room ought to go up. Let me practice this. I just want to make sure. Could everybody please put your hand up just once? Everybody, sir, your hand, ma'am, everybody, keep them up. Keep them up. I want to see it. Okay. Rob, your hand's not up. There we go. Okay, good. Okay, I just wanted to make sure everybody could do that. That's good. Now, listen. The reason jurors don't talk is because they're afraid. The number one fear in America is the fear of public speaking. It comes in ahead of the fear of death and snakes. They would rather be in a room full of rattlesnakes than have to talk to you. Right? That's because they're like afraid we're going to judge them. They're afraid of what their peers are going to think. They're afraid of giving the wrong answer. It's our fault. We can correct this. This is very correctable. Voir dire goes something like this, usually. Good morning, ladies and gentlemen of the jury. My name is Robert Hirschhorn. I have the privilege to represent the defendant in the case. This is the voir dire phase of the trial. Voir dire is French. That means to speak the truth. We are here to find 12 fair and impartial jurors. So please, talk to us. That sucks. That's stupid. That's ridiculous. That's for a prosecutor. We don't do that. Think about it. Good morning, ladies and gentlemen. Well, that's good. That's okay. If it's the morning, that's good. Okay? My name is Robert Hirschhorn. The judge just introduced you. I represent the defendant. The what? The what? We don't represent defendants. We don't have clients. Those are the ones that get convicted. Those are the ones whose appeals you have to write. We have Billy Joe Bob. We have Minnie Smith. Use their names. No more defendant or client. Okay? Next. This is the voir dire phase of the trial. No kidding. We know that. Voir dire is French. That means to speak the truth. Who cares? Have you ever been to a cocktail party and said, by the way, what do those words voir dire mean anyway? They don't care about that. They want to know how OJ could get off. They want to know how you can represent people who are guilty. So, stop. And then, we are here to find 12 and impartial jurors. How many of y'all are here to find 12 and impartial jurors? None! We want 12 people that have the courage to acquit. We have 12 people that can say, not guilty, right? That's what we want. So by your saying we're looking for 12 fair and impartial jurors, what the jurors are thinking is, okay, I'll give him answers that makes him think I'm fair and impartial, even though I'm not. Get rid of we're looking for fair and impartial. What I want you to replace it with, this is, I'm in Texas, I call it visit. This is our chance to visit. You should say this is our chance to talk with each other. I'm going to ask you questions. I'm going to be as honest with you as I can be. And all Billy and I ask is that you be as honest as you can with us. That's all we're asking. All right? And see how we're doing. We're wide open. We're telling the jurors, be honest. Okay? Now, the third problem is this. How many of y'all get this? They lie. Anybody get that? Every hand should go up again. Of course they lie. Why? Because we tell them to be fair and impartial. The judge tells them to be fair and impartial. Prosecutor tells them to be fair and impartial. You be the one to have the courage to say, look, everybody has bias and prejudice. Everyone does. I do. I'll give you an example of a bias and prejudice I've got. I couldn't help someone charged with burglary. I couldn't do it. My house has been burglarized, my office, my car. As much as I'd like to think I could be fair, I couldn't be fair. That doesn't make me a bad person. I'll give you another example. President Bush. Can anybody think of a kind of case where President Bush, think vegetable, I'll help you. Think vegetable. What kind of case? Say it. Broccoli. President Bush couldn't be fair in a broccoli case. Why? He hates the shit. He can't stand it, right? That doesn't make President Bush a bad person. It just means that in that particular case, he couldn't be as fair as he'd like to. Ma'am, could you share with me a kind of case where you feel you couldn't be as fair as you'd like to? You know, you get the answer. Well, sir, could you share with me? The point is, get the jurors to talk about there's nothing wrong with having some bias and prejudice, because we all have it. You got to get it out on the table, folks. You got to talk to these folks about it because it's true. All right. Now let's go to what our goal is. We call it the Zen of voir dire. Look good, feel good, sound good. That's all we want to do. And by the way, a lot of this stuff, I stole it primarily from two people, and I'll cop to it. My hero, my patron saint, Terry McCarthy, and Cat Bennett. These are all their ideas that work in jury selection. Look good, feel good, sound good. And the best way to do it, as Terry's going to teach you in cross, is to be a good listener. Now, Terry's not going to teach the listening part because you're going to be in control in cross, but the point is you are letting the jurors talk. If they are doing the talking, then you're looking good, you're sounding good, and you're feeling good because you're getting the information. Now, I want to give you all some tips for voir dire. Number one, questionnaires we've talked about. I'm going to give you some examples of them in just a few minutes. Number two, ordering topics. This is cool. This is very cool. Primacy and recency. You've already heard about it today. Jurors will remember the first thing and last thing you say to them. If the first thing you talk about is your client's prior record, they're going to remember that. And it's not good because they're going to go to the guilty room with it. If the first thing you talk about is Billy Joe Bob not testifying, they're going to hold that against you in the guilty room. Don't start off with problematic areas. Don't start off with areas that are an irritation for you. Start strong. End strong. Start your voir dire strong. End your voir dire strong. The problem areas, whether you have issues of homosexuality, unwanted sexual contact, prior conviction, the defendant not testifying, any of those problematic areas, put in the middle of your voir dire. Start strong and end strong. You'll be amazed because that's what the jury's going to remember. So in the Brown case, talk about, depending on your theory of the case, whether it's consent or misunderstanding. Talk about the reasons why people have misunderstandings. Talk about that book, Men Are From Mars, Women Are From Venus, and how people perceive things differently. Talk about these kinds of issues. Talk about reasons why a person would falsely accuse someone of a crime. And you'll be amazed at the information that you get. Next, case law. Now look, in my view, there's not many cases you need to remember with voir dire. And I told those of you in federal court or in jurisdictions where you don't get voir dire, I'd have a case for you. Here we go. Voir dire permits a party, this is a key word, party, not the judge, a party, to establish a relationship, if not a bond of trust, with the jurors. Okay? Now you're sitting there saying, that's pretty interesting language, Hirschhorn. What do I care about some case from Texas? Well, it's not a Texas case. Look at this. Supreme Court. Powers. 111 Supreme Court 1364. 111 Supreme Court 1364. 1991. So the next time when you go home, I want you to file this motion for attorney participation in voir dire, and I want you to cite this language out of the Powers case, that a party is entitled, and if you're doing the questioning, judge, I cannot establish the relationship that the United States Supreme Court says my client and I are entitled to. Here's another one, by the way. What's the one objection a prosecutor has in voir dire? What's the objection? say it again, arguing your case, trying to commit the jurors to the facts, right? And you stand there and say, ah, well, okay, and the judge is saying, you know, don't argue the case, counselor. Well, look at this language. The voir dire phase of the trial represents the juror's first introduction to the substantive, factual, and legal issues in a case. The substantive, factual, and legal issues in a case. So what I want you to do next time is stand up. Well, you should be standing up anyway, I guess. And you say, now what? You got to watch this. Again, stole it right from Terry McCarthy. Watch this. As your honor well knows, help the judge. As your honor well knows, the United States Supreme Court has said that the voir dire phase of the trial is the juror's first introduction to the substantive facts of the case. And I'm simply following what the Supreme Court has said, your honor. Right? Now look, the judge has got to go, okay, because you're doing it. Right? I mean, it's going to be very hard for the judge to say no. The worst, I promise, the worst the judge will say to you is, well, keep moving. You know, move along, counselor. You know that shit they learned in Reno? You know that judges school there? Right? There's only 2 courses there, man. Move along and denied. Right? That's it. Then they get to ski and gamble, right? So they'll routinely go back to move along, counselor, and then they'll get back to whatever the judges do, and you get right back into doing your voir dire, okay? So it's a great case. Now you're saying, Robert, what's the cite to it? Look at this. Powers versus Ohio. It's a great all-in-one. It's like an all-in-one kind of case. It's wonderful. Powers versus Ohio. I want to say one thing about Batson, and here's what it is. Number 3 is where I want you to key in on, because all y'all are good trial lawyers, you know about Batson, but look at number 3. See, now I'm guilty of the lobotomy, because look at this stupid word I used right here, commencing. What the hell does that mean? Prior to starting your voir dire, request that the prosecution put on the record the body language or nonverbals. You know how prosecutors say, I thought the juror was inattentive or paying more attention to the defense lawyer. You know those kind of lame excuses they give to justify their peremptory strikes? Well, before you start your voir dire, go up to the bench outside the presence and hearing of the jury and say, Your Honor, I want the prosecution to put on the record right now the body language or nonverbals of any of the jurors that they notice. Because we don't want them to come back at some point later on in the jury selection and say, oh, well, a person was inattentive, right? Now, what's going to happen? 99 out of 100 times the judge is going to say what? Denied, right? Because they just came back from Reno, right? So that's fine. What do? Look at this one. Look, you ready? When you start your voir dire, I want you to pick, you know, the members of the class you think they may be keying in on, and I want you to say, you know, folks, I noticed you were paying quite a bit of attention during the prosecution's voir dire. You were, weren't you? Anybody not paying attention? Go ahead and raise your hand. Nobody's going to raise their hand, right? So now you're starting to build a record. You know, I generally do that not just to the class. I do it to all the jurors, all right? So I try to foreclose the prosecution from doing this. The other thing I really encourage lawyers to do in Batson stuff is that you want to cross-examine the prosecutor. What a nice trip that is, huh? That, for being overworked and underpaid like every one of y'all are, that's one little tidbit, that's one little perk or penny we might get, right? To cross-examine a prosecutor on Batson issues. And then request their notes. I like, you know, because my feeling is anytime a witness testifies, you should be entitled to any written documents or statements they've made. They may hide behind this work product crap. It's not work product. It's a written document they relied on. So I would request that you be allowed to look at and cross-examine them from their notes. Request that it be copied, sealed, and made part of a record at the end of your Batson hearing. Okay? Here's something, number 9. Think about this. Did the prosecutor fail to strike similarly situated jurors? In that federal death penalty case we did in Florida, we noticed that all the African-American jurors who had a family member that had been arrested, the prosecution struck. But the white jurors who had family members that had been arrested, the prosecution did not strike. We thought we'd set up a perfect Batson issue on that. As Tony said, those great guys were acquitted in that case, so we didn't have to take it to that point. But the point is, think about looking at it from that perspective. All right, let me go back to my tips. Next one, honesty. You got to be honest with your jury. You know, if you think there's different views, and talk to the other faculty members, because people, and I respect different opinions on this. Our opinion is if you think there's a good chance it's coming in, deal with it. Because if you don't talk about Billy's prior record in voir dire and it comes in at trial, I think you're sunk. So if you think there's a chance it's coming in, I want you to deal with it. And it goes something like this. I want to be the first one to tell you that a number of years ago, or last week, or whenever it was, last year, just yesterday, Billy, I like this, pled guilty. And I want you to know he's got this prior record. Now, some people feel that when you commit a crime and you pay the price, the slate is wiped clean. And I'm visually doing this for the jury. Slate is wiped clean to get something happening with them, getting them thinking about wiping the slate clean. And other people feel that once you've committed a crime, you're always a criminal. Sir, tell me how you feel about this. Go ahead and do it, sir. Some people feel that slate is wiped clean. Other people think once a crook, always a crook. How do you feel about it? Okay. And ever get a bad answer like that? Right. Oh, bullshit. Everybody's gotten a bad answer in voir dire, right? Now watch. I'm going to was that a bad answer? Well, it depends. Did you like it? No, right? How do you know when you get a bad answer? I'm going to help you with this. It's very simple. Your sphincter muscle gets really tight. That's how you know it's a bad answer. Now look, here's how you deal with a bad answer. Sir, I want to thank you for being so honest. It takes a lot of courage to be that honest. Thank you, sir. By the way, is it all right if a little bit later we visit some more with the judge on this? Is that all right with you, sir? Sure it is. Of course it is. All right, now, sir, how do you feel about this issue? Okay, and tell me why you feel that way. Okay? Can you think of an example of where someone may have done something in the past and was falsely accused of something simply because they had done something in the past? Have you ever heard of something like that happening? Why does that happen? People, assumptions. Ma'am, how do you feel about that? Classic juror, right? Put her on the spot, right? It's a real uncomfortable moment, isn't it? I get the sense you're feeling a little nervous. Oh, no problem. The question was, some people feel that if a person has committed a crime, the slate is wiped clean and they start over. And other people feel once you commit a crime, you're always a criminal. How do you feel about it?
I guess it either way.
Mm-hmm. Well, right. And here's another, right, here's another classic voir dire answer. I'd have to hear the evidence first, right? It's that bullshit answer we always hear, right? I'd have to hear the facts of the case first, right? Here's how you deal with that one. Watch. Well, ma'am, can you share with me an example of where you think that a person having a prior record would have nothing to do with the case they're on trial for? Can you share with me an example like that?
So someone did something when they were young and they were drinking and it was stupid.
Mm-hmm.
I don't think they're necessarily going to do it when they're 30 and whatever. But if someone does something, if they broke into a house and they're breaking into another house, they may be a criminal. I'm doing it all the time.
Okay, sir? Yeah. Yeah. Sure. Let's deal with it. Right, exactly. Because look, don't be afraid of this stuff. A bad answer is a good answer. Why is a bad answer a good answer? Because you got a shot at getting them off for cause. So, sir, what about a situation where 5 years ago Billy pled guilty to burglary and now he's on trial for burglary again? Some people feel the slate is wiped clean. Some people feel once a burglar, always a burglar. How do you feel about it? All right. Give me an example of where a person would be accused of burglary. What are some reasons why they'd be brought to trial if they had a prior record, other than they did it? Can you think of any other reasons why they would be brought to trial or falsely accused? Now, how do you feel about that kind of situation? Now, you can only do this once. Don't screw this up. You can only do this once. I'm sorry, sir. I didn't hear you. Would you mind repeating it? Sir, I'm sorry, I didn't hear it. Wouldn't be fair. Mr., your name is Mr. Mr. Lentine. Sir, you heard Mr. Lentine say that wouldn't be fair. What's your reaction when Mr. Lentine says?
see what he's saying.
And why do you disagree with Mr. Lentine? Why wouldn't that be fair, sir? Prejudging a case. Ma'am, how would you feel if people would prejudge a case? What's your reaction to that, ma'am? That would be wrong to prejudge him. And why do you feel that would be? Okay, you see my point. Okay, you can really, even on these problematic areas. And when I got a juror that's saying, you know, once a crook, always a crook, I'm going to take them back and say, can we visit some more in voir dire? I'm going to get them up for cause. I'm going to say, look, let's be honest with each other. You've told us that a person that commits a burglary before on trial for burglary, you think they probably did it. And my sense is that I would probably have to prove to you that he's not. Not that the prosecution has to prove their case. I'd have to bring you some evidence, wouldn't I? And this feeling you have about once a crook, always a crook, you've held this feeling for a while, haven't you, sir? Yes. And wouldn't it be fair to say that you feel fairly strongly about this, don't you, sir? Yes. And wouldn't it be fair that if Billy were charged with something else, you could be an absolutely fair juror, but because he's charged with the same crime that he did before, you couldn't be as fair as you'd like to be. Wouldn't that be fair to say, sir? Yes. 9 times out of 10, you'll get yes. And then the last two I like to say is, you've been really honest and candid with us. I have the sense that, you know, because you hold these feelings deeply and you've expressed them strongly, I have the sense that nobody could talk you out of this position, could they? Right? You know, the prosecutor, nobody could they? You know, what? Nobody could talk you out of this position, right? And is it all right if I ask Judge Goodperson to excuse you from being a juror in this particular case? Is that okay with you, sir? I guarantee you're going to get, sure, fine, go ahead. Okay? So really, it's okay to take up these sensitive issues, and I'm telling you, you'll really get the jurors to talk to you about it, and you'll end up getting more strikes. Next, E. Establish rapport. I'm sorry, E. 3 E's. Let me give them to you. E number 1, establish rapport. Now, let me tell you what is not rapport. You ready? Sir, are you married? Yeah, are you in a serious relationship? I'm in a serious relationship. That's amazing. Amazing. That's great. Ma'am, do you have children? I have children. What a coincidence. How many kids do you have? I've got 1 and 1 on the way. That's not rapport, folks. That's bullshit. We don't do that anymore. What I want you to do is talk to the jurors about the real issues in the case. Number 2, elicit information. What does that mean? That means let the jurors do the talking. Get the information on the questions and the issues in your case. Let the people talk. The ultimate power in jury selection is giving control to the jury. The ultimate power in jury selection is giving control to the jury. They will not disappoint you when they go back to deliberate. And number 3, educate by having them teach each other. And what I mean by that is this. I could stand up all day and talk about self-defense. But the jurors are not going to listen to me because I'm a criminal defense lawyer. I'm a public defender. I am a hired gun. I get crooks off, right? But if I have the jurors talking about self-defense, ma'am, can you share with me an example, please, of a time where you felt threatened? Right now. Okay. Classic, isn't it? Can you think of another example? Anytime. Oh, that's a good one. Have you ever heard of a situation where someone felt their life was threatened? Have you heard of something like that happening?
Yes.
What should a person do if they truly feel their life is threatened and they have some kind of weapon near them? What do you think a person should do in that situation? I'm sorry, ma'am, I didn't hear it. Use it. Ma'am, your name is? What's your reaction with Ms. Milner? Yes, sir. Tell me why. Tell me why you feel that way. Right. Now, because he's talking about, well, I don't see what the problem is. Someone's coming at me, it's me or them, I get them, right? And by Billy. By the way, touch Billy. Be willing to touch your client. Because if you can't stand your client, neither can the jury. That's why you want to humanize that person, okay? Establish rapport, elicit information, educate by having them teach each other. Next, I'm going to go through these quickly. Open-ended questions. Not, does anybody in the jury panel have any opinions or feelings? That's not an open-ended question. It's pick a person and say, what are your opinions? What are your feelings? Now, some of you are in a jurisdiction where the judge won't allow you to do the individual voir dire. You got to ask these general questions. Here's what I suggest. Ask the question one way. Everybody that says yes, raise your hand. Then ask the question the opposite way, requiring a no answer, right? That way, you find out who thinks yes, who thinks no. Some people won't raise their hand. And you say, Ms. Jones, I noticed that while we were asking this question, I didn't see your hand raised. How do you feel about this? Judge is going to shut you down. You say, Judge, I asked it both ways. The juror didn't raise their hand. I need to know. So in general question jurisdictions, ask the question both ways. Open-ended question. Who, what, when, where, why. This is the exact opposite of everything Terry and the rest of the faculty are going to teach you on cross. It's the exact opposite. This is the time where you really want to, you don't want to ask a question you know the answer to. What you want to find out is, what do the jurors truly think or feel? By the way, I like think or feel. Some jurors will say to you, well, I think this. It's my opinion that. That tells you that's a cerebral juror. Some jurors will say to you, I feel this. That tells you it's a visceral juror. Use think or feel. Some jurors will say to you, I see what you mean. That's a visual juror. That's a juror that learns with their eyes. That's a juror that needs lots of demonstrative aids. And demonstrative aid does not have to be expensive, folks. The most effective demonstrative aid I've ever seen was written on a chalkboard. It had 3 words on it. And it was a key to winning a case. So demonstratives don't mean expensive. So if the juror says, I see what you mean, they're visual. If they say, I hear what you're saying, that means they're an auditory juror. They learn through their ears. So think about that with your jurors. Looping. Have you all gotten looping yet? Yet? Anybody talk about it this morning yet? Oh, Terry McCarthy, he's such a genius. He's the one that at least taught me this looping concept. We did some of it here. When you get a good answer in voir dire, here's what I want you to do. Use the juror's name and exact words. Use their name and exact words. Go to the other juror and say, Miss Smith, Mr. Jones said that if a person's life threatened and there's a weapon, Mr. Smith said he'd use the weapon. I did no interpretation there. I didn't say, do you agree or disagree with Mr. Jones? I repeated the good stuff. Loop good things. Do not loop bad. This is another important one, because then the jury will pick up on the bad. Loop the good answers. Use the juror's name to make them feel important. Use their exact words. That's what the loop is. It's a very powerful tool. Cause coffin, we talked about it. We'll talk some more in the workshop. This is where you use close-ended questions. Close-ended questions when you go for cause. No open-ended questions, in my opinion, when you're trying to get a juror off for cause. And use these words. Human nature. Isn't it human nature that when someone has seen a lot of stories or read a lot of publicity, isn't it human nature that they'll form opinions? And there's nothing wrong with that, but that's what human nature is. And wouldn't you agree with me that isn't it human nature that once you form an opinion, that once people form opinions, it is oftentimes difficult to change that? Isn't that human nature? You preface your cause questions with human nature, and then you're saying to the juror, it's okay if you feel this way. All right? Okay. How to peel the attitude onion. This is really helpful with jury selection. I'm almost done, I promise. But I don't care so much about jury selection. It'll really help you in your relationships with people that are important to you. Trust, empathy, not sympathy. Not sympathy, empathy. Hearing a juror's world. I haven't had a family member killed, but I know what it's like to lose someone that I loved a great deal. So when you have jurors that have had some kind of experience, you may say to them, I haven't had the experience of having a person that I cared about a great deal killed, but I know what it feels like. I know the pain that goes with losing someone you love and care about a great deal. That's empathy. And that says to the juror, you hear their world. You hear their world. Honesty, we talked about, you got to be non-judgmental. When you get those bad answers, when that sphincter muscle gets tight, thank the juror for being so honest. Reinforce the juror by saying it was courageous to say that. There's a split among some people on this. I do not like to say at that point who else agrees, because usually do everything and should never use a weapon. How many of y'all agree with Miss Smith? I'll go row by row. If somebody doesn't raise their hand, I'll say, ma'am or sir, I noticed you didn't raise your hand. How do you feel about it? Okay? I try to stay away from the negative feeding frenzy. And that happens when you get a bad answer and you follow it up with, who else agrees with that? And you get all these bad answers, all right? So be non-judgmental, respect your jurors, and you got to listen to your jurors. Listen, listen, listen. Okay, I want to go into one last series. It's kind of interesting. It's amazing the answers jurors will give you in written questionnaires. I want to share with you some of the ones we've gotten over the years. This is called a free association question. What's the first thing that comes to your mind when you think of, and it's defense attorney and prosecutor? Fascinating. This is from the William Kennedy Smith case. Now, I want you all to pretend you were the lawyer. It was on TV. It was the only jury selection in a high-profile case ever on TV. What's the first thing that comes to your mind when you think of defense attorneys? Look at this answer. Leeches. Anybody's sphincter muscle getting a little tight on this one. What's the first thing that comes to your mind when you think of prosecutors? You ready? Check this out. Losers. I feel a lot better. Here's another fascinating question. Name 3 people you admire or respect the most. Number 1, Ronald Reagan. All right? Number 3, Hillary Clinton. Kind of an interesting mix, huh? Number 2, check this one out. Madonna. Drug case. Keeper. Not guilty! How many of y'all have small kids or grandkids? You know, under like 5. Okay, cool. Please list your 3 favorite people. You ready? Number 1, Nelson Mandela. Number 2, Jesus. Number 3, Barney! You know. Keeper. Not guilty. This is a fascinating question. It is fascinating. For years, judges and prosecutors fought us on it. Now, judges, it comes in all the time. Please list your 3 favorite TV shows. Ma'am, what's one of your favorite TV shows? Living Single. Sir, one of your favorites? Anything. Third Rock from the Sun is very cool. Sir, one of your favorites? Ma'am. 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 Melrose Place. One. I'm sorry? Drew Carey. Right, it's fascinating, the diversity. Check this out. 3, your favorite TV show? Look at this. The Beverly Hillbillies. And then, of course, we come down here, your 3 favorite people. By the way, here's a new question we've added this year. Please list the 3 people you admire the least. It is fascinating. That is a fascinating. You want to not only find out who they admire the most, find out who they admire the least. It is fascinating. Number 2, Martin Luther King. Number 1, Jed Clampett from the Beverly Hillbillies. Okay, this was a drug case. It was a California drug case. 20 tons of cocaine actually seized. Not a conspiracy, actually seized. The judge said, I'm not giving you attorney voir dire, but I will give you a questionnaire. So we got this questionnaire. And the question was, in light of all the publicity surrounding the drug problem in America, what opinions or feelings the judge made us put in, if any, do you have about people charged with possessing huge quantities of cocaine? The judge did the questioning and went like this. Do any of you in the jury panel have such strong feelings about drugs it would affect your ability to be fair and impartial? Raise your hand. I see no hands. We'll go on. So I grab Michael Nassatir's arm and I say, Michael, why don't you show him a couple of these answers to see what the judge thinks? So we approached the bench, and here was the question. Charge now. Ready? Here's the first answer. Answer is, kill them, Deuteronomy's 1921. Or this one. In 19th century China, Maoist China, thank you very much, opium traffickers were put to death. China has no opium problem today. Coke is worse than opium. Why do we let these scum live? So the judge was perplexed. So he calls the jurors up and he says, you know, you clearly have strong opinions. Why didn't you raise your hand? And the juror said, we didn't want to be singled out. We didn't want to feel like, we were being put on the spot. All right? So that's why you really got to fight for these kinds of things. All right. I've got a lot of other stuff, but I'm out of time. Look, here's what I want you to do tomorrow. Tonight, I think it's a very simple assignment for tonight. I think it's probably your easiest night assignment tonight. Assignment number 1, think of the questions you're going to ask your clients in the interview that will encourage them to talk and learn to be a good listener. Number 2, what I'd like you to do for jury selection tomorrow is for your case, just find 2 or 3 areas and write just a couple of questions that are open-ended in each one of your areas. The recipe we're looking for is getting you to ask simple, open-ended questions and being a good listener. Then from there, we'd like you to loop and do some of the other things. But just come up with a couple areas and make them the hard ones, folks. Don't make them the simple areas. Make them the hard questions that you have to deal with back home in your jurisdiction. And we're going to do that. Try these techniques. We've got the new century coming. I promise every one of you, if you do these things, we can win these cases. But before we go, what are the 2 words we want the jury to say when we go home? Okay, hang on. I want to make sure that prosecutors in Seattle, Washington, Miami, Florida, in Maine, and San Diego hear it. Now this time, I really want to hear it. I want every prosecutor to get the message that we are going to be fighting for the 2 words we all love on the count of 3. 1, 2, 3. Not guilty! Y'all are great. Have a good day. Go to the cave. Thank you.